Please be seated. Okay. I hate IT sometimes. Welcome you to the second hearing that we have, oral submission that we have, Seventh Court of Appeals sitting in the Fourth Court of Appeals courtroom. They graciously allowed to use it, and it's a great courtroom. We enjoy it. Great people here. So we'll go on and call the docket. Give us your announcements. You should have received a letter from the court telling you that time splits are 20-25. The appellants have 20 minutes. The appellants have 20 minutes, and the appellants have 5-minute rebuttal. So the appellants do not have to ask for a reservation of time to rebut. You may want to limit your first part of your argument and say, I'd like to reserve the remainder for rebuttal. It doesn't work that way either. You get 5 minutes. So on your 20 minutes, you're free to use all of it or less than it. It's your choice. We do ask questions or tend to ask questions. We have some attorneys that are listening to the first argument in the back, and they heard us ask some questions. So please expect some questions and answer them as succinctly as you can. If they need some explanation, that's fine. But we've kind of over time learned when somebody doesn't want to answer our question, and that does not necessarily bode well. So answer our questions and we'll go on down the road. So we'll go on and call the docket. The case that we are about to hear is 07-23-00275-CV, the City of San Antonio versus Patricia Diaz. And for the appellants. Thank you.
Good morning, Your Honors. Edward Pena on behalf of Patricia Diaz to my right here.
Thank you. You have the floor.
Thank you. May it please the court. My name is Jackie Stroh. I'm here on behalf of the City of San Antonio. The issues we're going to talk about today all concern claims of discrimination and retaliation asserted by appellee Patricia Diaz, along with state law intentional tort claims. The points I'll be discussing today, time permitting, are that Ms. Diaz failed to timely exhaust her administrative remedies as to all or some of her claims, that she failed to prove pretext for her sex and age discrimination claims in response to the city's articulation of a legitimate non-discriminatory reason for her termination. With respect to her retaliation claim, she likewise failed to prove pretext in the form of but-for causation and also failed to establish a prima facie case because she did not engage in any protected activity. And with respect to her intentional tort claims, those are barred by the Texas Tort Claims Act. The city retains its immunity for those claims. And contrary to what Ms. Diaz asserts, she did not plead any constitutional claims.
With regard to the prima facie case regarding sex and age discrimination, are you in agreement that she did cover those?
For purposes of this appeal, we're not contesting that she did not establish a prima facie case for those two claims, focusing on pretext. So first, with respect to the exhaustion of administrative remedies, the Texas Labor Code requires a written sworn complaint to be filed within 180 days of the adverse employment action in question. Here, the only thing Ms. Diaz filed within 180 days was an unsworn letter to the EEOC. Although the administrative rules relax the requirements and allow for amendment of complaints to correct defects like being unsworn, and also allow an unsworn declaration under Chapter 132 of the Texas Civil and Practice Remedies Code, a Civil Practice and Remedies Code, to substitute for a sworn complaint. Ms. Diaz did neither of those things here. As we explained
with regard to the summary judgment motion, I don't believe that was an issue that was raised that way. If my understanding is correct, there was about a 1 paragraph discussion regarding the 180-day issue, and I think it said something to the effect of the plaintiff was terminated on September 1st, 2020, and so, or I may be wrong on those dates, and so
It was
accordingly.
September 1st, 2020.
And so accordingly, the only thing that she could pursue are claims for termination and not for anything that happened to her before that date.
Right. And so that was the argument made in the motion for summary judgment. We are reasserting that argument here as well with respect to the hostile work
It
environment claim.
seems to be a
It is.
different shade of an argument that
It
you're
is.
making.
It's a step beyond, and we've explained in our brief how the city's entitled to raise these subject matter jurisdiction issues for the first time on appeal, and that's what we're doing. It is a step beyond, no doubt. This particular argument has to do with the unsworn nature of the complaint and the lack of any amendment to it to correct that defect. The latter submission to the Texas Workforce Commission, first of all, was not an amendment to the EEOC complaint, and even if it was, it did not comply with Chapter 132 because, first of all, it didn't have a complete date of birth, and second of all, it lacked the place of execution.
So if we were, assuming arguendo, we were to agree with you, would we dispose of it under the summary judgment aspect or under the pleaded jurisdiction aspect?
You know, Your Honor, that's really, it's a distinction without a difference. It, you know, the
But it is because under summary judgment rule 166A, you cannot raise new things that were not raised in the trial court. So that would necessarily have to leave pleaded jurisdiction, wouldn't it?
That's actually not, I'm going to disagree with you, Your Honor, on even if it were raised by, we had pursued motion for summary judgment, we could still raise for the first time on appeal jurisdictional issues that pertain to the city's immunity. So the procedural vehicle doesn't matter. But if the court's more comfortable doing it under the plea of the jurisdiction, that would be fine. But the Supreme Court has said the title of the document doesn't matter. It doesn't matter if it's titled a plea of the jurisdiction, a motion for summary judgment. You can raise immunity issues. You can take an interlocutory appeal. It's really a distinction without a difference.
How does that work with, given that the plaintiff has an opportunity to amend her charge of discrimination or the issue she's putting on file? If it's raised for the first time in an appellate brief, does she get to go back now and amend? Or at what point do we run the risk that she's having the rug pulled out from under her without any opportunity to fix the problem?
Well, since we've raised it in our appellate brief, there's been no amendment. So, so I'd say she's had plenty of opportunity to amend and hasn't done so.
Do you have
So-
any authority for the proposition that you're stating? That as far as procedurally, it doesn't matter?
What, that you can bring a jurisdictional issue for the first time on appeal regardless of the
Yes, with
procedural
regard-
vehicle?
With regard to a summary judgment?
I mean, I don't have a sign off hand, but I do know that to be the rule. I can certainly provide that to the court post argument. But even if the court were uncomfortable, the city absolutely did file a plea to the jurisdiction and a motion for summary judgment. So even if the procedural vehicle mattered, the city covered its basis by filing both in this
Is
case.
that something we can raise sua sponte? I mean,
It
because we're
is.
dealing with jurisdictional issues, can't we go, oh, by the way, we noticed you haven't filled out your form correctly, so we're going to pour you out now?
I think the court could, but it doesn't matter because we've raised it as well for the first time on appeal. So.
And explain to me why you think they didn't fill out the form properly.
So first of all, the EEOC letter is unsworn and it doesn't,
I thought the opposing counsel argued, though, they said it under penalty of perjury as
Not-
like a declaration.
not the original submission, and I'll get to the second submission as well. The original submission was just a letter signed by counsel for the appellant and attested to or approved, I think it was, by Ms. Diaz. The second submission was not submitted to the EEOC. It was a second submission by plaintiff's own admission, both in the trial court and in their brief, a second submission to the Texas Workforce Commission. There was a separate part of the form that,
One or the other or both? Which one triggered action by the government?
I'm sorry, I didn't hear
Which
you.
one triggered action by the EEO? The first letter or the second?
Triggered action.
She got a right to sue letter at some point.
Oh, she got a right to sue letter from both
So that
of them.
means one of those, the administrative entity began its investigation.
That's right, but that doesn't,
Okay, which letter triggered the beginning of
I'm
the
sure
investigation?
I'm sure it's the initial unsworn letter
Okay.
submitted to the EEOC.
And if they acted on it and said it's okay,
That doesn't establish anything. That doesn't establish anything. It doesn't comply with the Texas Workforce Commission's requirements that first it be unsworn. I mean, first that it be sworn, and if it's not sworn, that it constitute a substituted unsworn declaration under Chapter 132. And yes, the Texas Workforce Commission is signed under penalty of perjury. There's a separate box right next to it that says, if local rules require, here's a part where you sign and have it notarized. That's blank. The only thing that's signed is the one under penalty of perjury. So she's definitely trying to comply under Chapter 132, but missing are the date of birth and the place of execution, both requirements specifically enumerated in Section 132.00D.
Certainly, we've run into that on occasion with the Civil Practice and Remedies Code, that section, we deal with electronic filing and things like that. There's a different provision that says, don't file things that contain birth dates because that's personal information. And so I guess I'm struggling to understand if that's a distinction without a difference. I understand that's what the statute requires, but there's also a provision that says you don't include that information in the public record.
But it's not e-filed with the
Sure.
with the court. I mean, I'm talking about it submitted to the Texas Workforce Commission. Those sort of redactions are governed by Texas Rules of Civil Procedure and Texas Rule of Appellate Procedure. Those don't apply here. We have the unredacted Texas Workforce Commission submission in the record, and it doesn't have a complete date of birth, and place of execution is not something that would have to be redacted anyway, and that's not in the submission either. But even if the court were to disagree with me on that, it's clear that the only employment action that was, I guess, preserved or exhausted through timely administrative remedies is the complaint about her termination. I know on appeal, she's got some weird language in her brief about continuing violation theory and stuff like that. I don't know what that's about. It certainly doesn't apply here. A termination is a discrete employment act. It's not part of a hostile work environment, so it could never save an untimely hostile work environment claim. We have cited cases like that, holding just that in our brief.
Was hostile work environment included in either of the charges?
It was, but she admitted in the trial court and admits on appeal, even though she also argues this continuing tort continuing violation theory, admits that she's using the hostile work environment activities solely for context for her termination claim. So there's no hostile work environment claim for the court to decide. It's solely based on termination. So moving on to the sex discrimination claim, the city, even if the court were to disagree with us on all the timeliness issues, there's no evidence to support any discrimination or retaliation claim. So first, with respect to the sex discrimination claim, the city has established a legitimate non-discriminatory reason for Diaz's termination. It's the San Antonio Administrative Directive 1.75. It's in the record. There's plenty of testimony about how she had a lower level employee perform free labor for her. His statement that he didn't feel free to refuse, that he was on company time. And we've cited cases that say both violation of a city policy and theft, and we contend that this is theft of city labor.
arguing that did not occur.
I'm sorry?
She's arguing that did not occur.
And that's completely irrelevant.
Why?
It's irrelevant. We've cited cases in our brief. If it would be relevant, which it's not, it would be relevant only to pretext, not the existence of a legitimate non-discriminatory reason. But it's not relevant to pretext because the case law establishes that disputes as to whether or not the Carino statement is true or whether Diaz is credible or things like that are no evidence of pretext. Furthermore, her own subjective beliefs that the city engaged in sex discrimination, not evidence of pretext. Her complaints that the investigation.
They'd be evidence of pretext.
I'm sorry?
Why couldn't they be evidence of pretext? If they were utterly false and the city knew that, but yet they proffered him, why don't that be evidence of pretext?
Well, first of all, there's no evidence that the city knew that. I mean, the evidence.
That's not my question. My question is, if they were utterly false and the city knew that, could that be evidence of pretext?
No.
Making all this up to get rid of her because of her age.
Well, evidence of pretext would have to show that it's not that and this is important because there's actually case law I know of and that's cited in our brief with respect to retaliation that says, no, that's not enough. In fact, one of the factors for pretext or but for causation in the context of retaliation is whether the underlying reason is false, but it doesn't mean what you think it means. What that means is it's the actual reason for the termination is sex discrimination or age discrimination or retaliation. The fact that the underlying reason is not supported or there's conflicting evidence or something like that, that's not evidence the actual reason was sex discrimination or the actual reason was age discrimination in the way that a comparator might be, or the way that something other than a stray remark might be. For example, comments by the decision maker himself demonstrating, like if this were a race discrimination case, demonstrating racial animus or something like that. But simply because the underlying reason might be false and evidence the city knew it, which there's no evidence of that in this record, that is not evidence in and of itself that the real reason, and that's pretext, evidence that shows that the real reason for the employment decision was sex discrimination, age discrimination, or retaliation.
Hasn't the U.S. Supreme Court gotten away from this pretext plus distinction in some cases, though, to say that if there's evidence that the explained reason by the employer is false, then an inference can be drawn that it was being done for an illegal reason? I think following that, maybe Reeves from the Fifth Circuit has addressed that issue as well, that sometimes we can simply look at the falsity as providing an inference.
But Your Honor, there's no evidence.
I'm not saying in this case.
Right.
I'm challenging the legal position you're taking, which is to say there must be pretext plus in all cases.
And I don't think I'm saying pretext plus.
Okay.
What I'm saying is it's not even evidence of pretext because there's no evidence that it's on the basis of sex discrimination or nothing that would give rise to a presumption or inference that it was on the basis of sex discrimination.
Let me step back. I'm going to ask a more basic question
Okay.
because this is something that I thought was a little unclear in the briefing. I've got an opinion about what I think it is, but I just want to see what your position on it is. Sometimes in your motion for summary judgment, you talk about using that the evidence is conclusive pertaining to the reasons for terminating the plaintiff. And obviously some of the cases don't talk about it within terms of conclusive evidence. It talks about at the second stage of the McDonnell-Douglas test, you've got a burden of production and not a burden of persuasion. Can you help explain to the court what your position is here, particularly within the context of a summary judgment, because state summary judgment practice may be a little bit different than how the federal courts have used summary judgment practice?
I don't think it's any different than the federal courts use summary judgment. I think the Texas courts and federal courts are now on bar, but I understand what the court is saying. We could never conclusively prove that the underlying reason is true because Diaz disputes that and she disputes it in her affidavit. So we could never do that. And the city's not arguing that we could do that. What we did conclusively show is that assuming it were true, and there's certainly evidence in the record to back up that's what happened, and that's the stated reason for the termination in the record, and there's nothing to rebut that except perhaps comparators or these stray remarks, which I've explained in my brief, and I'll explain if I have time as to why that's not evidence of pretext. But they're certainly conclusive that that is a legitimate discriminatory, non-discriminatory reason for her termination. So to the extent it's unclear, I mean, that's maybe the word was used loosely in the motion for summary judgment.
To make sure that we're on the same page, your position is, look, when we're dealing with the first two steps of McDonnell-Douglas, we're only dealing with whether a presumption of discrimination exists under the prima facie test. And at least with regard to sex discrimination, we're saying, okay, you don't contest at this point that there may be a presumption. That presumption is then rebutted at the second stage, but we don't look at whether the reasons are actually true or actually false until the third stage of the test.
I think that's true, but even if you needed some sort of conclusive showing at the second stage, the conclusive showing would be that is the reason for the termination, not the underlying charge
Not
is
the underlying.
false. And I think that's probably a better answer to Chief Justice Quinn's argument, a question, is that the conclusive showing and why it wouldn't be evidence of pretext is because the city's burden at the second stage would be to show that that was the actual reason for the termination, not whether the underlying charge was false.
Because there are times when an employer makes a decision based upon the information they have, and it turns out the employer's wrong.
That could definitely be the case.
But that isn't evidence necessarily of illegal employment discrimination.
That's right. That's exactly right. So moving on with respect to the other evidence of pretext that Diaz offers, the evidence of comparators and these stray remarks and actions. We've detailed the problems with the comparators in our brief. The Texas Supreme Court has held that the comparators have to be virtually identical to the complainant, and they also have to be in the context of sex discrimination of a different sex. They can't be within the plaintiff's own protected class. So the plaintiff offered 6 comparators, 2 of whom were female. So those comparators don't even apply. 3 of them didn't even hold her same position. All but 1 had a different supervisor. 1 had a different director. 3, I believe, I'm going to have to check my notes, 2 or 3 were terminated, and none of them committed the same violation or a violation of sufficient seriousness comparable to Ms. Diaz. Moreover, the evidence in the record is that the only person who committed a similar violation, which was having an employee perform free labor for a superior, was terminated. So the comparators themselves are no evidence of pretext.
With regard to the person who fell asleep in his pickup, is there an argument that could be made there that that's the equivalent of time card theft?
Right, but the part that's missing is the abuse of authority. So that was the real, and if you look at Mr. Newman's deposition testimony, that was the real problem, is 2 aspects of that were the real problem. One is that she used a lower level employee to perform free labor. This is unquestioned. The only dispute is whether she knew he was on duty or not, but it's undisputed that she used him to perform free labor for her at her home. He was a lower level employee. She was an assistant manager of the department. And the other problem was that in Mr. Newman's, for example, his conversation with her about the charges, she simply failed to appreciate the seriousness of that charge and the power dynamics involved. And in fact, Mr. Carino's own statement was, well, I didn't think I could say no. You know, I'm a lower level employee. I didn't think I could say no. So that's what's missing. And in fact, we cited.
Matter if he wanted to do it as opposed to, I didn't think I could say no.
It doesn't matter, but I mean, it sort of adds to the seriousness of the violation, the fact that he said he didn't feel that he could say no. But there's an abuse of authority anyway. And as I mentioned, it's just about whether that was the actual reason relied upon by the city and not the underlying truth. I see my time's up. Thank you so much.
Thank you, counsel.
May it please the court.
Counsel.
Good to be here with your honors.
Good to see you.
Your honors, I have been having difficulty trying to understand the city's position with a couple of matters for many months. And one of them, I think I figured out within the past 2 days. The city has been saying for months that Ms. Diaz filed both an EEOC complaint and a Texas Workforce Commission complaint, and that she had these 2 discrimination processes going on simultaneously or at various times, and that that was not going to save her timeliness argument. I finally understood by going back through the original discovery why the city is mistaken and confused about this, and that is because the city, Ms. Diaz initially filed a complaint for unemployment compensation. That's a complaint that goes to the Texas Workforce Commission. The facts are that Ms. Diaz's relative died and she was out of state when the response was due, and therefore they denied her unemployment compensation on that unfortunate technicality. Now, that was a complaint for unemployment, had nothing to do with discrimination. But it is in the record. That was the very first Texas Workforce Commission documentation that you will see. However, Ms. Diaz says, look, I was dealing with a death of a close family relative. I want to appeal the denial of my unemployment compensation. And she does. Now, that appeal takes several months, at least 6 months. To my recollection, it was at least 6 months, and she is corresponding with the Texas Workforce Commission during that time, providing them whatever information they need and so forth. But that is not a discrimination complaint. Now, when you look at it in the record, you see that it's the same logo, Texas Workforce Commission, but you will not see Civil Rights Division.
Let me ask you a question. You talked about you were going back through the discovery when you came across this. Is this part of the summary judgment record?
It was part of the summary judgment record. However, there was a, and this is another thing that has made it confusing for the parties. There was at the very outset, well, let me put it this way. Ms. Diaz terminated September 1, 2020. She had 180 days to file her EEOC complaint with the Texas Commission on Human Rights Civil Rights Division. Okay, now by this time, she's got this parallel unemployment compensation appeal going, but we're not talking about that. We're talking about her timely filing her discrimination complaint with the EEOC. Now remember, if you file with the EEOC in San Antonio, you have you have also filed with the Texas Workforce Commission Civil Rights Division, because we don't otherwise have that agency in San Antonio. And because of the work share agreement that our legislature has worked out, anything that you file with one will be good for the other. And this is done, of course, to avoid duplication of services and expense to taxpayers.
So you're just saying your argument is you file in one place, it covers both.
We cover them both.
Okay.
My understanding of what opposing counsel is saying, though, is that without regard to whether you filed one or you filed two, the most recent one or the timely filed one doesn't contain all the information under the Civil Practice and Remedies Code that it's required to contain.
It did require, it did contain everything, because the EEOC immediately responded to it. Now, their response was unusual, however. They respond, yes, sir.
Well, I think opposing counsel says it doesn't matter if they responded to it or they acted on it. You still have to dot your I's and cross your T's for the statute.
Agreed, and she did.
Okay, so you have 180 days from termination, correct?
Yes, sir.
You filed, what, 148 days?
148 days.
Okay, that filing, did it have the birthday on it? That opposing counsel said it needed to have a filing, needed to have?
Well, in that, within that period of time, Ms. Diaz receives a 17-page, if memory serves me correctly, and this is, by the way, the subject of my motion to supplement the clerk's record, because I did not discover until 2 days ago that it's not in the record. The EEOC the EEOC's 17-page questionnaire to Ms. Diaz, which was their very first communication with her, acknowledging that she has filed an EEO complaint. In that 17-page questionnaire, they are telling her, we received it, we acknowledge receipt, we have assigned you EEOC cause number 451-2020, so forth and so on. Now, please provide us this information. And I think they set forth 17 pages worth of very specific information that they want and that she fills out and submits.
So and I want to get back to what I think opposing counsel is arguing, because she's raising the issues as the appellant. My understanding, what she's arguing is to say, look, you can have had this notarized, and if you have it notarized, then, you know, there are things you follow that have it notarized. If you don't have it notarized, then you've got to fall under Chapter 132 of the Civil Practice and Remedies Code, if I remember the number correctly, which says you've got to do the following things, and it will suffice as basically being notarized or being appropriate under the circumstances. If it's not in the form, I'm trying to understand your position that if it's not included on the face of the form, why the other evidence matters.
Because as a dual filing agency, all of their forms serve both agencies. And their response was, we received your EEOC charge. We are assigning it charge number so-and-so. Please provide us this additional information that we need in order to process it. It's filed. At that point, it is filed. Now, it is a fact that because it was a 17-page, and I have frankly, in 35 years, I've never seen a 17-page questionnaire, but they did it, and I credit them for that.
So your argument basically is, since they deemed it filed, it's filed, doesn't matter if the petition or the statement had defects in it. They
Correct.
accepted it.
Correct. Correct.
Okay.
And-
The opposing
and-
counsel says, no, that's not the law. The law is you've got to dot your i's and cross your t's. Do you disagree with that as being the law?
I do. On this situation, yes, I do, because here, the amount of information that they required of her was significant. It was not a questionnaire that she could have sat down and filled out in a couple of
Seriously, did they
days.
include her birth date? Did they ask her what her birthday was?
Yes, they included what her birthday was.
What about the
And-
place of execution?
Sorry?
What about the place of execution?
The place of execution, meaning,
Well, that was the other defect that the city was complaining of.
well, she clearly signs EEOC Form 5, which says, and I quote it in my brief, it says, signed under penalty of perjury, and this will include and this will be counted as a dual filing with the Texas Commission on Human Rights Act, Civil Rights Division. And I further agree to cooperate with both agencies to see this through. And if my address changes or telephone number changes, I will promptly notify the commission. That is almost a quote of what she signed.
Some
Okay?
places-
Is this in the record?
Yes, ma'am.
For us.
Some places, though, I think what Justice Parker's asking about is when you look at an ordinary affidavit, it'll say State of Texas, County of Bear at the top, or it'll say signed on this day in San Antonio, Texas, et cetera. Is there any place in the record that we have that indicates the location of where she was at the time she signed and verified that the statements were true?
Yes, it's EEOC Form 5,
Okay.
which I think is March 10 was the day that they, now remember, EEOC Form 5 is not something that Patricia Diaz has any control over. That is a federal form that they type up and they send it to Patricia Diaz and say, sign this if it's correct, make any corrections you need to, but sign it and return it to us. And that's what she did. So she had no control over the March 5th deadline. But in the questionnaire, the questionnaire has already settled all this. The questionnaire to her says, we have received your EEOC complaint. We've assigned it EEOC charge number 451-2020- and we need more information to begin our investigation. Please provide this, and this. So it's done. It's filed at that point.
Curious, is her response to that 17-page questionnaire under oath or unsworn declaration?
It's under oath. It's under oath. It's also under oath, even though we already have a Form 5 that clearly says it's under oath for both federal and for state purposes. They also required her to submit her evidence under oath, which she did. Now, it wasn't just the 17-page questionnaire. She also had to attach any supporting documentation, which she did. And it took her some time to do that, but she did it all and it's in there. Now, what I did notice was that it was not in our clerk's record, and that's why I have asked the court to permit us to add that, because that is the missing piece that explains this.
Okay, what you just said, with regard to your motion to supplement the record, I guess is what you referred to. Something is not in the current appellate record that was part of the record before the trial court.
You know,
We can't add to the record items that were not before the trial court.
yes.
So are you telling us that with regard to your supplement, these were items before the trial court that were omitted from the appellate record?
I believe that, now, let me be clear. When Patricia Diaz receives the City of San Antonio's motion for traditional summary judgment and or plea to the jurisdiction, she answers it, and then she amends her answer later on, and she also files an amended complaint later on, but all within the scheduling order set by the court. So all of that is timely. I don't think we have a disagreement about that. I believe it is in the second amended, because that picked up all discovery to date, but I don't think that it was picked up in the clerk's record, and that's what we're asking to supplement. But in terms of it having been exchanged by the parties,
First record that was sent to the appellate court. I mean, we may be playing semantics, but when you say clerk's record, and I say appellate record, clerk's record is part of the appellate record, but you're saying it should be part of the appellate record. It was in the trial court.
it was in the trial court, the amended portion of the trial court. Okay. All right, now, if I may touch another point here that is very troubling to us, and that I think goes directly to animus in a way that I have rarely seen in many, many years of practicing law on both sides of this docket. And that is that the alleged discriminating official here is District Director David Newman. And the record shows that he supervises or manages about 800 employees, a lot of employees. Patricia Diaz was one of them. Now, in there, he first learns that Patricia Diaz may have asked somebody to help her on city time by, he first says, an anonymous complaint, or I don't remember who it was if they told me. That's what he first says. Okay. Either way, her manager investigates it. He determines what happened. He issues a counseling to Ms. Diaz and a reprimand to Eloise Carreño, and it's a done deal, but it's overheard by one of the supervisors that report to Patricia Diaz. One of her subordinates overhears this, and he calls their boss, all of their boss of the 800 employees, and he says, hey, Mr. Director, I just heard this, that Patricia Diaz did this, and they're just not doing anything about it. Well, they did do something about it. They disciplined both. But in any event, David Newman seizes upon that opportunity to get rid of Patricia Diaz. Now, how do we know that?
Can I stop you right there for just a minute? With regard to the reasons for doing so, and I'm going to read this from your brief and make sure that this is a position you're taking today. Patricia Diaz is not claiming that she was terminated because Director David Newman erred or relied on a flawed investigation.
Correct.
So whether Newman or somebody else at the city was mistaken or correct in believing that she had improperly had this employee do something on time is not an issue that we're looking at. We're only looking at, now that we have the information, what do we do with it, right?
Yes, sir.
Okay.
Yes, sir. Because Patricia Diaz had always felt that David Newman, the big boss, treated her much more harshly, much less favorably, anytime there was a discretionary matter.
Okay, so whether the statements from the other employee were true, whether they weren't true, whether they were coerced, I think you mentioned this point, not an issue, at least for what we're talking about and the issues on appeal. We're only looking at, we're going to make a decision to terminate or some other disciplinary action. And I guess what you're saying is that the discipline was unwarranted given what the city knew?
Yes, Judge. We have a 24-year, 10-month employee with an impeccable record, all in the same department. She didn't float around different parts of the city, all within solid waste management division. Impeccable record.
Okay, so the appellant's taken the city's taken the position that we've articulated a legitimate reason for terminating. We've cited a policy for terminating. And your response to that is what? That other employees were treated differently? Or tell me
Yes.
why you think
Yes.
the trial court was correct in denying the motion for summary judgment, the plea to the jurisdiction.
Yes, sir. Yes, sir. No doubt it's a case of disparate treatment. We have identified all of the employees that were treated much more favorably, but let's not go there for right now. Right now, what I did want to mention was that we have a unique situation with regard to race discrimination here, the likes of which I've never seen before, in terms of actual probative evidence, and that is that Elizabeth Carreño, the low-level person that went to her mother's house and helped her, with Patricia believing he's off duty, Elizabeth Carreño, when he comes back, his supervisor starts yelling at him, "Where have you been? You've been gone for 2 hours," and this and that. And Elizabeth has very limited English speaking ability. And if you yell at him, he gets even more nervous. And he asked for translation assistance of Tariq Esquera, the person that was yelling at him, his assistant manager. He asked him, he starts yelling at him.
Counsel, if I may.
What Tariq does, I'm sorry, what Elowith, the
Counsel.
low-level employee does, he writes out what happened in Spanish.
Counsel, if I may, your time has expired. Why don't you take about a minute and wrap up real
Yes,
fast?
sir. Thank you. He writes out in Spanish as best he can because he cannot answer in an articulate way to Mr. Esquera. That statement is in the record. Now, what does David Newman do? He orders the Office of Municipal Integrity to go take new statements. They take a new statement from primarily Spanish-speaking Elizabeth Carreño that is at odds with his first statement that he gave on his own and that cannot be reconciled. Those two cannot be reconciled. And when I asked Mr. Newman in his deposition, well, you know, there's two statements. Yeah, I know there's two statements. Well, did you give them equal weight? No. Well, which one did you go by? Well, the one by OMI. Well, what about the first one that was handwritten by the witness? He says, I didn't give that any weight at all.
I think we understand what you're saying. Your time has expired, though.
Thank you, Your Honor.
Thank you. Rebuttal?
Can I ask you a question before you begin?
Sure.
Given that the law allows a complainant to amend their complaint, do you have any objection to us looking at this other evidence in the record of what the plaintiff may have responded to in response to the EOC, assuming it's in the appellate record? I mean, it's not in the appellate record, assuming it's in the trial court record.
It's not in the trial court record. And to be honest with the court, if I'm being fair, since we are raising it for the first time on appeal, I probably shouldn't oppose supplementing the record with those materials. But I will say they were never put in the trial court record. They're actually not a part of the clerk's record. They can't be made part of the appellate record under those strict rules. But if I conceded and allowed it, it wouldn't, not me personally, I mean, conceded for the court to allow it. It wouldn't matter anyway. The representations made during the argument are totally false. They're not sworn. They're not made under penalty of perjury. In the Texas Workforce Commission complaint, there's nothing about place of execution. None of that is true. So even if the court were to consider them, I mean, the court can look at them as attached to the plaintiff's brief or permit a formal supplementation, but they don't actually show any exhaustion anyway. I may come back to the exhaustion point if I have a little bit of time. I'm glad Justice Doss mentioned articulation of a legitimate non-discriminatory reason, because I went back and looked at the materials during break, and that's the standard. It's not proof, conclusive proof, or whatever, it's articulation. So, but as far as the stray remarks on the sex discrimination claim are concerned, no, opposing counsel didn't get to those to mention those, but we have ticked through them in our brief. I mean, they are distant. None of them are proximate. They have any one of a number of problems. Either they're distant, they weren't made by the decision maker, they're gender neutral. I mean, she complains of things like, you know, David Newman used a harsh tone. That's completely gender neutral. We cited case law for that. She cites stalking and graffiti that happened in the 1990s as evidence of pretext for termination that happened in 2020.
What we do, and I think the Supreme Court a couple of years ago struggled with a similar question. What do you propose we do under the circumstances where Newman's the supervisor, but the ultimate decision to terminate or other disciplinary action is made possibly by somebody else, possibly in human resources? That seems like a harsh approach to say, well, we're not going to consider what Newman did because the HR office is the one that made the decision.
The HR office didn't make the decision. I don't think it's disputed that Newman was the decision maker. Now, OMI, the Office of Municipal Integrity, certainly did investigate at his request and made a recommendation as to whether there was a violation of city policy. But Newman is the one who made the termination decision. So, and beyond that, even if you're talking about OMI, I'm not aware of any evidence in the record where she pointed to anything any of the members of the OMI committee that did the investigation did. I mean,
and that's my point. The way at least the argument that I think you're arguing, it would allow employers to effectively isolate somebody who may have discriminatory animus by saying, okay, we're going to hand that off to somebody else to make the hiring and firing decision.
but David Newman didn't do that. He handed it off to do the investigation, but he's the one that signed the termination letter. So there's nothing like that here. Just super briefly on the age discrimination claim, She admits the only evidence of pretext she has are the same ill-fitting comparators she offered for the sex discrimination claim, and they're made worse because two of the individuals are within the protected age class, so they can't actually be used as comparators. And David Newman was actually older than Patricia Diaz at the time he fired her, and we cited case law showing that that's yet another reason to discount an age discrimination claim. As to retaliation, we ticked through again all of the supposed protected activities. Again, they were gender neutral. They were never couched in terms of sex or age discrimination. They were very distant in time. Many, if not all, didn't involve David Newman. And for the same reason, she can't prove pretext. Thank you, Your Honors.
The case is submitted and you are free to leave, and we will be a short recess until about 11 o'clock. Thank you.